Good morning. It's Bernard Nomberg with the Nomberg Law Firm in downtown Birmingham. We hope that wherever you are, you're safe and warm and not having to deal with the storm up in the northeast or even the north part of our state, where I think we've gotten a little bit of snow in the middle of March, which is not terribly uncommon around here. Today we are back with another one of our live weekly video sessions talking about an area of the law, and we have addressed in the past several weeks overviews of the work comp laws, compassion for our clients, mediations versus trials, as well as social media and the client. And if you missed those weekly videos or want to go back and look at them, they're all posted on our Facebook page. You're certainly welcome to review them and comment at any point in time. And if you have questions, certainly send us messages or call the office at 205-930-6900. This week we've got another topic that applies to our practice every single day, and the topic that we're discussing today is what to do if you're injured on the job. How do you initiate a workers' comp claim? What to do, what are the steps you take, how are you eligible, those kind of things. And we're going to take just a few minutes to go over those things and hopefully be able to answer questions that you might have or that may pop up in your situation or someone who you know. Again, I'm Bernard Nomberg with the Nomberg Law Firm, downtown Birmingham, and we handle cases ranging from workers' compensation matters to personal injury claims, as well as Social Security disability. And today we're talking about the steps to take if you're injured on the job, what to do. The very first thing that you should do if you're injured on the job is to report your injury and your accident. Make sure that your supervisor or someone, I don't know if it's your boss or the crew foreman, someone in the supervisory or management level, or the department, maybe if you work at a big plant, maybe there's a medical department, someone with a supervisory level, more so than a coworker, needs to be informed that, one, you got hurt on the job, and two, that you were injured and that you need medical care. If you feel like the injury was bad enough to warrant medical care beyond maybe an on-site medical department checkup or look at you, you need to make sure that you go to the right department. Again, it could be your supervisor, it could be HR, it could be a workers' comp department. Every business is a little bit different, but the theme or what needs to be done is the same. You must tell them that you got hurt on the job while you were doing your job, and that you're injured to the point where you need medical care, and that you'd like to be seen by a workers' comp doctor. Hopefully the company that you're working for at the time has workers' comp coverage, and they'll put the motion into place. Many of our cases, unfortunately, because clients just don't know the proper procedures, their claims can run afoul when they don't report the claim that they got hurt, or that they had an accident, or that they had a repetitive motion, like they work on an assembly line, and that they fail to tell someone in management or fail to tell somebody in supervisory level or ownership that because of what they were doing at work they got hurt and that they need medical care, and then they want to be sent to a workers' comp doctor. So those are it's the critical two things that initiate a claim. In general, there are certain conditions that must be met in order for benefits to be available to the injured worker pursuant to the Alabama work comp laws. And I'll just go over just a few of those things and give you some real life examples of those. And unfortunately, these are the kind of things that lead to us needing to file lawsuits to pursue benefits, or to get in touch with the adjusters or the workers' comp claim departments with the insurance companies. These are the things that we address every single day for our clients when claims are not approved or they're being denied for various reasons. And it's way too easy for an insurance company or an employer to deny a workers' comp claim because certain criteria are not met. And that's not necessarily the fault of the injured worker or the employee, because they don't know what the proper procedures or policies that are in place. And it certainly is on them, though, that they need to find those things out. But these constants do remain, what I'm about to go over. First and foremost, you must be an employee working for an employer, and that's someone who does work for wages, not volunteer work, not someone who's a farm laborer, domestic servants, casual employees. Those kind of things are not subject to the Alabama workers' compensation laws. That's not what I'm referring to. They must be an employee who works for an employer, and the employer must be a business that's covered by law to the work comp acts for our state. And that must be an employer that has 5 or more employees. And I can get into the minutiae or the details about that if you have those kind of questions. You're certainly welcome to type them right here as we're going along, or you can send me a message after the fact. I'll be glad to address it with you. The injury must result either from an accident or something that occurs on a repetitive basis, or an exposure to, for example, chemicals, those kind of things in the workplace. An accident is defined, and I'm going to read straight from the laws so you'll know what it is. An accident is defined as an unexpected or unforeseen event happening suddenly and violently with or without human fault, producing at that time an injury to the physical structure of the body or damage to an artificial member of the body by accidental means. I know that's a mouthful, but you kind of know what an accident is. It's something that occurs, and it's not necessarily the fault of the injured worker. Someone slips and falls on a wet floor. They're in a car collision. Someone accidentally runs over a foot in a warehouse by a forklift operator. Goods fall down off of some shelves in an inventory warehouse and hit the employee. Those are accidents. The accident must arise out of and in the course of employment. And that's usually a big argument right there between the employer and the employee when denying a claim. There must be a relationship between the expected work activities of the employee when the accident or the event occurs, and he or she is fulfilling the duties of that employment and engaged in something incidental to it. And there's a whole host of cases, and every case is fact specific, but it must arise out of and in the course of employment. Additionally, proper notice must be given to the employer. The law requires notice to be given within 5 days, or you can give written notice up to 90 days after the accident. And again, every case is a little bit different and fact specific. Lastly, the injury must result from the accident. Does the medical doctor, the medical provider, believe that there's a connection, causation, between whatever happened at work to cause the injuries? And again, that's a big area of litigation that we deal with all the time. Every case is fact specific. But those are the 4 general things that must be in place in order for a claim to exist and to go forward. The employee must work for an employer which is subject to the Alabama work comp laws. The injury must result from an accident that occurs, and the accident must arise out of and in the course of the employment. And proper notice must be given to the employer of the accident and the injuries that warrant or need work comp medical care. Again, I'm Bernard Nomberg, in case you just missed us, or just joined us. I'm with the Nomberg Law Firm in downtown Birmingham. We appreciate you stopping by for a few seconds or a few minutes or for the whole thing. These are the very core issues that we deal with here at the office, that the average person who gets hurt on the job does not know what necessarily the steps that they need to take. But the first and foremost is to put the employer on notice that there was an accident. Most of the time it's witnessed. Some of the times that it's not, and that can lead to some other issues that eventually may lead to litigation. The other part of that is that there must be a request by the injured worker for work comp benefits, meaning medical care, related to being hurt on the job. And if those things aren't in place, typically the claim will be denied, and then we have to start our work. That's why you need a lawyer sometimes in these workers' comp matters, and I would be glad to help out or to answer any questions that folks may have. A couple of other final details to tell you about. There is sometimes when a person is hurt on the job and the workers' comp approved doctor takes them off of work, or the employer can't accommodate the restrictions that have been assigned, then weekly workers' compensation benefits are typically paid. And unfortunately, they're very low in our state compared to other states. Now, that's for a whole nother day, a whole nother topic of conversation. But in order for those weekly comp benefits to kick in, so to speak, to start paying, there's a waiting period of 3 days. On the 4th day, the benefits will start. However, if you're off as much as 21 days, then you can recoup the first 3 days that were not paid. It's a convoluted set of laws. We'll be glad to go over those things with you, but that's unfortunately the way the laws are drawn up right now. There are some exceptions that might negate an employee's claim for benefits, and I want to go over just a couple of those as we close out today's video session. Some of the things that can negate an employee's claim for benefits might include when the accident is caused by the willful misconduct of the employee, meaning did you intentionally do something that caused or led to your injuries. Another thing that could negate or create a denial of the claim is whether or not the injured worker was intoxicated or from either alcohol or illegal drugs, and that due to the intoxication, the accident led to the injuries of the injured worker. Now, there's also a line of cases, though, that just because someone tests positive for a drug screen after the accident doesn't necessarily mean they're going to be denied from benefits. For example, if someone is injured in a car accident, but the accident themselves that they were in had nothing to do with something they did, meaning it was caused entirely by someone hitting them from behind or running them off the road, and just because they tested positive on a drug screen doesn't necessarily preclude them from having benefits. You have to, there has to be a review of the facts and the medical information of whether or not being impaired caused or created the event or the accident, the injuries. A couple of other circumstances that may negate an employee's claim for benefits is whether the accident and injuries were caused by a third person or a fellow employee for personal reasons that are unrelated. That goes to one of our topics we talked about actually last week about being injured through violence in the workplace. Remember, I gave a couple of examples about a woman at a fast food restaurant in North Alabama was injured, in our opinion, relating to things that she had done the previous day in the workplace with these boys who were in her restaurant. Unfortunately, the judge ruled the other way, but in her ruling was that these were personal in nature. In comparison, the other example I gave last week was the woman at the check cashing place that escaped from a robbery and kidnapping situation, and she broke bones when she was escaping that harmful situation. That was due to the very nature of her job and her trying to escape. The court felt in that case that those were covered. So it really is a fact specific for each of these types of situations. There's several other examples I could give that would negate a person's claim for benefits, and maybe another day we can go over those things. Our caseload, the cases that we have, the ones that require us going to court, typically involve some of these circumstances that and examples that I've just gone over. So if you have any questions or concerns about your specific situation, maybe some of these criteria may address your case, your situation, please give us a call, 205-930-6900. David and I would be glad to talk to you, go over your case with you, and I hope this has helped address a few questions or concerns that you have out there. Please continue sending in your questions. Next week we'll go over some of the questions that we've received in the past few weeks. We sure appreciate those who watch us on the live video feed or later on after we post it to the firm. And we'll have some more topics in the upcoming weeks. Thank you again for stopping by, and we hope to see you guys a week from today. You'll have a good day. Take care.